Can I now welcome Sarah Davidson, a bit later than we asked Ms Davidson to come along, and I'm sorry to have kept you waiting like that. Sarah Davidson is the former Director General of Organisational Development and Operations in the Scottish Government. And I would begin by inviting Ms Davidson to take the affirmation. Ms Davidson, would you please raise your right hand and repeat after me? I solemnly, sincerely and truly declare and affirm.
I solemnly, sincerely and truly declare and affirm
that I will tell the truth, the whole truth and nothing but the truth.
That I will tell the truth, the whole truth and nothing but the truth.
Thank you. May I invite Ms Davidson now, please, to make a brief opening statement.
Convener, thank you for the opportunity to make this short statement. The key points that I wanted to convey to the committee are set out in my written statement, but I thought it would be useful for context to briefly summarise my roles and responsibilities within the Scottish Government. I began working for the Scottish Government in 1995 and was deployed in a variety of roles and business areas. Latterly, after a period of maternity leave in 2012 to 2013, I returned as Interim HR Director for around 5 months at the start of 2014. I then took up the role of Director General for Communities, then moved to be DG Organisational Development and Operations when that role was created in July 2017. As DG ODO, I was a member of the Permanent Secretary's executive team and held a number of corporate responsibilities, as well as providing leadership and line management to the directorates of Communications, Ministerial Support and Facilities, Digital, Financial Management, Procurement and Commercial, People and Social Security. As the Permanent Secretary set out in her own evidence to the committee, staff in the majority of these directorates hold corporate professional roles and work across all of government. My line management role therefore focused primarily on supporting wellbeing, development and leadership, as well as fulfilling formal financial and management accountabilities. I left the Scottish Government in June 2019 to take up my current role. I have not retained any documents or information from my time with the Scottish Government, and nor have I had access to their systems since June 2019, including for the purposes of giving evidence today. In the timeframe available to me, I have looked at a few key documents provided by the Scottish Government which have been published by the committee, but I have not reviewed all of the material that has been published. Accordingly, I will be answering the committee's questions without the benefit of having such information to review, but I will of course do so to the very best of my ability, bearing in mind these limitations. As a former civil servant, I'm obviously subject to some continuing obligations under the Civil Service Management Code, and so there may be from time to time certain constraints which I have to respect. Finally, I am aware that the Scottish Government has asserted legal privilege over certain documents and information to which I may refer, and I must respect that position. I've noticed that other witnesses have declared membership of the FDA where applicable, and I'll therefore take this opportunity to note that I am an FDA Associate Member. Thank you.
Thank you very much, Ms Davidson. We'll move direct to questions from the committee. Can I have Margaret Mitchell, please, Deputy Convener?
Thank you, Convener, and good afternoon, Ms Davidson. In your written evidence, you clearly state that you were not involved with the development of the 2017 procedure. If that's the case, can you confirm that you did not initiate any correspondence, text, emails, and that you were not copied into any emails, etc., correspondence concerning this?
Not to the best of my recollection.
Okay, thank you. You were line manager to Nicola Richards, Director of People, and you had oversight of her team, including Judith McKinnon, Head of People Advice. Did either or both make you aware of any concerns in relation to the judicial review during the period 16th of October to the 8th of December? That was the Scottish Government's legal position being established about then, and the first set of answers given on the 15th of October. If so, who raised them and what were these concerns?
So I recall becoming aware at some point, probably within the broad timescale that you're referring to, that questions had been raised in the judicial review procedure about the role of the investigating officer. I didn't know the detail of them. I wasn't close to the handling of the judicial review, and my understanding was that these were being managed in the context of proceedings, and that proceedings were continuing as had previously been planned. So I can't recall. I think it's likely it would have been Nicola Richards who brought that to my attention, but I can't recall precisely when.
Did she express concern?
I think it would be fair to say she expressed concern. She certainly knew that concerns had been raised and that further information was being sought from Judith McKinnon about those issues, and that these were being subject to discussion with lawyers, and I wasn't privy to those discussions with lawyers at any point.
And she expressed concern. Could you just elaborate on the nature specifically of the concern?
I don't think I can say any further in relation to that. There was an issue which had been raised. They were looking for further information, and it was clearly an issue which was of some concern to the lawyers.
And you aren't able to say if it was about her involvement with the complainers and up to during the procedure, and then the fact that she was an investigating officer?
I can't recall the precise detail. It was about the role of the investigating officer, but which particular part it was, I can't recall.
Okay, thank you. In our evidence committee last week, Judith McKinnon stated that on the 31st of December 2018, she contacted the relevant director saying she'd found further documents, including texts with Miss B, but was told to pause on sending anything through. Can you confirm if you were the director she was referring to?
So Judith McKinnon was dealing directly with SGLD on the provision of documents at all points. So no, and I don't think she would have referred to me as a director. I was the Director General.
So she didn't tell you she had uncovered all these documents at that time?
Not that I recall, no. She was dealing with the litigation team at SGLD in relation to the provision of documents.
And were you aware that she was told to pause with that information?
So I was aware at that point, clearly, that the prospects of the case were under review. So it would, and that therefore the further commission, to an extent, must have been in doubt whether or not that commission would go ahead. So it wouldn't surprise me if she had been told to pause, but I can't recall now whether I knew that at the time.
Okay. You stated you had no involvement with the judicial review until mid-December 2018 when you were asked by the Permanent Secretary to compile a report for her to help inform next steps. How did you undertake that test? For example, where did you source the relevant information and from whom?
So the vast majority of it, start again. My recollection, as I think I say in my written evidence, was that there were three main parts to that advice. That it covered financial advice, which I was given by the Principal Finance Officer, legal advice, which came from a variety of sources but was collated and passed to me by the Director of Legal Services, and handling advice, which by my recollection was in some part reflecting advice about legal handling, which again would have come from SGLD, and in some part communications handling, which would have come from the Communications Directorate.
Okay. Specifically in regards to further documents identified by Ms McKinnon in late December 2018, in compiling your report and taking cognizance of that, was there anything included in that informed the later decision of the Scottish Government to concede? So, thinking of the timeline that the Scottish Government produced for this, for the committee, by the time that I was pulling together and collating that advice, the further productions which Ms McKinnon had passed into the process were known, and those informed the legal advice that I was given. So, yes, that legal advice reflected the lawyer's view at that point of the additional information that Ms McKinnon had found. My recollection is I was pulling together that advice between something like the 23rd and 27th, 28th of December. And again, I think the timeline suggests that the further productions that had been made by Ms McKinnon predated that. Okay. And can I ask finally, are you aware of any kind of time frame for police involvement, either directly being asked to look at something, or in a more generic manner to talk about harassment cases generally?
You mean within the organisation?
Yeah.
Oh. So I was aware at a number of points that the police were approaching people in the organisation, as clearly as it was their right to do so, as part of an investigation. I cannot recall now how that mapped against the timeline of the judicial review here.
So, police involvement at all? Could you state just how or when you were involved or aware that there was some police involvement at any kind of level?
I think I would be misleading the committee if I attempted to put a date on that. I was aware that at certain points, I'm guessing during the period between August and the following, it was right through the following year, there were times when the police were having conversations with members of Scottish Government staff. But I have no recollection of specific times at all. And I wasn't personally involved in that at all. So I think that's partly why the dates wouldn't have stuck in my mind at all.
So it would be August 2018, right through the following year, was it?
August 2018, yes.
Okay, thank you, that's helpful.
Okay, we move now to Angela Constance, followed by Alison Johnson.
Thank you, Convener, and good morning to Ms Davidson. Am I correct in saying that you were not involved in the development of the policy, but the Permanent Secretary was?
That's correct.
Okay. And you line managed Nicola Richards directly. Therefore, you line managed Judith McKinnon indirectly. But in terms of the investigation, you were not involved. Have I understood your...
That's correct.
Your written... Is that not quite unusual? Because you were a very senior civil servant. So
in a way, there was nothing usual in some ways about this particular investigation. It would be unusual in normal terms for the Director General to get involved in the investigation of an HR complaint. That would normally be handled within the HR Directorate with senior HR oversight from either Judith McKinnon or Nicola Richards. Because this complaint was being investigated under the Permanent Secretary's procedure, the decision was taken, I assume, by the Permanent Secretary, although it wasn't something that I ever discussed with her, that she would take the lead in being the person to whom the investigating officer reported. And given the need for, both, I think, to avoid unnecessary double handling, but also given the desire to maintain very strict confidentiality in relation to the complaints, there was no role for me as the Director General in the investigation, given that the Permanent Secretary was playing the role that she did.
okay, I appreciate what you were saying, that in normal times, that in your previous role you wouldn't be involved in HR investigations, but in this instance, your staff were involved, but you were cut out of the loop and they were reporting direct to the Perm Sec. Is that something you were comfortable with at the time?
It didn't cause me any concern. As the Permanent Secretary said in her evidence, and in a way as Mr Caquette indicated earlier when he was talking about his own role, it was not unusual by any means for senior professional advisors within the government to report directly either to the Permanent Secretary or to other DGs. The Principal Finance Officer, for example, would quite often provide advice directly to my fellow DGs or to the Permanent Secretary. And as somebody who was not an HR specialist in this instance, there was no obvious value that I would add by checking their homework before they presented it to the Permanent Secretary or to other DGs. So, no, that didn't give me any difficulty. That was quite normal. OK,
that's clear. And you were part of the Permanent Secretary's executive team and chair of the People Board. And you said something which struck me as quite unusual in your written evidence. You made a point of saying that you had no involvement in the Permanent Secretary's all-staff communication. I'm just curious as to why you felt the need to say that. It seems like a inconsequential thing to say, but civil servants are never inconsequential.
So I think what I was intending to convey there was that the People Board had a role in the government which was essentially about the corporate governance of the organisational development strategy. I think it occurred to me in drafting it that anybody who was not familiar with the corporate governance of government might not unreasonably think that the People Board, because of its name, might have been involved in the harassment procedure or in clearing all staff communications or something like that. So I included that to make clear that the People Board didn't have a role like that and indeed was not involved in any way in these proceedings.
Okay, and my next point, and my apologies if you've covered this with Margaret Mitchell, it's been a long morning, Ms Davidson. But around the 19th of December, you were advised that there was material found that had not previously been identified. This was for the purpose of the judicial review. Who advised you of this and how? What was it? Did you say it was Nicola Richards in the context of supervision or a meeting with her?
So I can't recall precisely who alerted me to that fact, but certainly I was, but it wouldn't have been Nicola Richards because Nicola Richards was away on holiday by that point. So it may have been the legal directorate, it may have been the permanent secretary's office, I think possibly the latter. There was clearly, as one would expect, a degree of concern about the fact that documents were turning up late in the process. This clearly caused concern to the individuals, caused concern to the legal advisors. And I think it's likely in that context that I would have been advised. And given that Nicola Richards was on holiday, I think it's most likely that it either was from the Permanent Secretary's office or from someone in SGLD.
Okay, thank you. And earlier in the year, you had already requested advice from SGLD as some of your staff were going to have to give evidence at the Commission. What did this advice cover?
So I think it was actually just a few days prior that I had sought that advice, certainly no more than a week or so. I think Mr Caquette, if I heard him correctly, said earlier that a commission on diligence is a relatively unusual process, and none of my colleagues who had been cited to attend had ever been involved in this before. As one might expect, there was a degree of anxiety about what was involved in going to give evidence in that format, and I therefore asked the litigation team in SGLD if they would provide some additional information for colleagues about, I think, some very practical things about what they might be asked, in what capacity they were there giving evidence, who would be present and so on. It was that kind of advice. Okay,
and at any point were your staff advised about how to do proper searches for documents to ensure that the right information was available at the right time?
Certainly my understanding would have been that that advice would have been provided from the outset by the litigation team in SGLD, either directly or via the coordination function that Mr Caquette referred to in the Permanent Secretary's office. I think that it became clear over time, and particularly towards the end of December, that searches had not been as comprehensive as they might have been, and therefore I think one might draw conclusions about whether the questions had been posed as clearly or as comprehensively at the outset as they should have been. But certainly my understanding is that SGLD would have provided that advice and that people would have been searching according to particular questions asked of them. Okay. Some of which were informed by the lawyer-to-lawyer correspondence that was happening at the time. Okay,
and the judicial review timeline, in your written evidence, you said that it could be interpreted that you had direct communications with Council between the 21st and the 29th of December, but you didn't, and you've asked SG to clarify that. What communications and when did you have at all with Council?
I had none at all.
Okay,
and that was why I queried that, because I didn't recognise it.
Okay, and were you cited on any legal advice?
No. So I guess, as far as I can recall, I was cited on no legal advice as the judicial review was proceeding. For the purposes of enabling me to collate the report to the Permanent Secretary at the end of December, I was cited on the legal advice which was relevant to the section of that report which SGLD contributed to, or at least I was cited on the components of some of that legal advice. And that would have been, but that was all related to that fairly late stage. I don't recall seeing any legal advice earlier in the process.
Okay. So we know that around the 21st of December, the Permanent Secretary asked you, and I think this is your word in your written submission, that you were asked to urgently collate various strands of advice received from senior professional advisors. Can you tell us why this was urgent? It may seem like I'm asking you the obvious, but it would be important to hear your understand. Why was this urgent?
So again, I was looking at the timeline supplied to the committee to refresh my memory on this period. Clearly, the commission had taken place on the second day of the commission had taken place on the 21st of December, and on that day as well, the timeline reminds me that Judith McKinnon had found additional documents which had been handed to the petitioner's senior counsel, and that there was a consultation that day with counsel. And while I wasn't privy to the discussions that took place at that at all, or the legal considerations, it was clear that this triggered for the Permanent Secretary a need to take stock on where the case was, and to take stock fairly urgently. There was another commission date set down. I forget if it's in the information. I'm sure it is here somewhere. But there was a commission date set down for either the very end of December or the very beginning of January, and the judicial review itself was due to start in January. So I think, looking at all of that, it feels fairly self-evident that if the Permanent Secretary needed to take stock, that needed to happen quickly.
Okay, so why you? Because you're out the loop. You've been cut out of the loop in terms of the investigation and the judicial review process. So why is she coming to you?
So it was not in any way unusual for the Permanent Secretary to ask one of her Directors General to carry out a particular task for her. That's something that we all did from time to time. By recollection, actually, it could have been one of a number of us. I remember a discussion in the Permanent Secretary's office where both I and one of my fellow Directors General were present when the discussion about commissioning this report took place. I can't now remember precisely why it fell down on my side. I think, to be honest, it may have been that I was due to be at home over Christmas and therefore had some more flexibility. So that was the context in which I was asked to do it. It may well have been, although again I can't recall, and it was the Permanent Secretary's decision to commission me, but it may well have been the fact that I hadn't been close to the detail was seen by her as being an asset in terms of being able to impartially pull together the advice that she needed.
Okay, so unlike some of your other colleagues, you were in the Maldives. So would it not have been more the norm for someone from SGLD to be pulling all of this together?
Had the Permanent Secretary purely been looking for legal advice, then yes, I think she would normally have gone to the Director of Legal Services. It could be the fact that she wanted to have financial advice as well, and of course the Chief Financial Officer sat within my area of responsibility. But again, as I say, it might be that she wanted the benefit of somebody who had not been as close to the matters that she was seeking advice on to pull it together. That meant she asked me. You'd have to ask her precisely what it was. That was my understanding at the time.
Appreciate that. And so you provide a report to the Permanent Secretary, and you state in your written submission that in that report you make no recommendations. But nonetheless, the Permanent Secretary comes to the view to concede the case. Now, we understand all about extensive legal privilege in this committee, but can you give us an insight into, the content other than the headlines in your report, that there was a section on finance, section on legal advice and section on handling? Your report may have had no recommendations, but it's clearly made an impact on the Permanent Secretary.
So my recollection, and again partly prompted by listening to Mr Caquette earlier this morning, was that certainly the component of that report which was about legal advice would have reflected what he was conveying, which was that a point had been reached where, I forget the exact terminology that he used, but a point had been reached where prospects of success were now looking very slim. I'm not saying those were those we used, but that was clearly what was being conveyed. And certainly the financial advice that was given would have reflected that legal assessment. It was the bringing together of those that was intended to enable the Permanent Secretary to take effectively a formal decision about how she wished to proceed.
Okay, I mean, that's quite a process-driven answer, and I can say that with respect. But let me put it another way. So, Scottish Government are pursuing a course of action. They are on the train lines, and they're heading in a very set direction. And we are told, we're informed by legal advice every step of the way. But it's you who provides a report, and then the train is brought to a screeching halt. How can that be explained?
So I think it's important for me to be clear that the report didn't contain my personal assessment of the legal advice or financial advice. I was going to say merely, but that maybe understates the importance of the document. But I was putting together in one place for the Permanent Secretary to assess the advice from lawyers that had been reached by that point, along, as I say, with other points for consideration. And therefore, I wouldn't want to in any way suggest that it was something unique that I had said that led the Permanent Secretary to reach the conclusion that she did. The advice that was in the document reflected SGLD's presentation of the legal advice at that point.
Okay, so you're collating everything in the one place. So, can you see, at what point did legal advice change? Are you able to pinpoint that?
So it was clear, and again, I'm going to rely on recollection here and what's in the timeline, that a combination of the substance of the documents which Judith McKinnon had identified later on and the timing of finding those had led to a reassessment of the prospects for the case. So I was not even myself close enough to all the legal process to that date to fully necessarily understand how that was the case. I think you need to be able to slot that understanding into an understanding of how the pleadings had developed over time, which I hadn't been close to and hadn't seen, and indeed didn't see at the time of producing this report. But clearly, both the timing of the production of these additional documents and the contents of them were such that they had led the lawyers to have the types of concerns that Mr. Coquette set out for the committee earlier today.
Okay, and my final question, Convener, is, I mean, it's a matter of public record that the court found the Permanent Secretary's decision report letter unlawful in respect of action that was taken in the circumstances which were perceived as unfair and tainted by apparent bias. I wonder, Ms Davison, whether you were surprised by that finding of the court, and given that you were involved in two exercises around lessons learned, both in terms of the investigation and in terms of the judicial review, I do appreciate that both of these lessons learned exercises were halted. But you must, even with the benefit of 2020 hindsight, have an impression here.
So I think I'd want to be clear in relation to the lessons learned exercise that, as you identified, particularly the second one of those in relation to the procedure, that there was not an opportunity for that to make any significant progress at all at the time that I was involved in it. So was I surprised by the terms of the concession? I suppose not at that time, because I had seen that final stage of evidence which was developing towards the point of concession. And of course the Court of Session itself never took a view on that because the case was conceded. Taking the whole process together, was I surprised that it ended at that point? In other words, that had been the case. yes, I was, but I think that was in the context of not having been close to neither to the investigation nor to the process of the judicial review. And I don't think there's really anything more I can add to that.
And bearing in mind, you commenced work to start lessons learned exercises twice. You know, was there anything that was learned in the short term?
So the first lessons learned exercise that I referred to in my written statement was intended to be the lessons learned exercise that I think is provided for in paragraph 11 of the procedure, which requires the Permanent Secretary at the conclusion of an investigation to see whether there are any lessons to be learned for the organisation arising from the matters that were under consideration. So I, as I say, began to draft that. Of course, it's important to remember that that was during the summer before any of these matters were in the public domain or indeed were known in the organisation beyond a very, very small number of people. It quite quickly became clear that it was difficult to comment in a lessons learned exercise on procedures that might have been inadequate in particular parts of the organisation without leading to the identification of where those things had taken place and therefore risking identifying the complainers. So that was one of the issues that made us pause on that. But then actually very quickly, the instigation of the judicial review proceedings themselves meant that it did not feel appropriate to be learning lessons from events which were themselves then very publicly being challenged.
So forgive me, I understand that the point you're making about process and you detail all that in your written submission. I suppose what to cut to the chase, what I was asking was, at the time, in the immediate aftermath, was anything learnt?
So my recollection of the lessons learned exercise, the one that we're talking about at the moment, not the one about the procedure, was that it led us to consider whether gaps that had been identified by the complainers in HR processes at the time, so the reasons that they'd given for why they felt they couldn't come forward at the time, we looked at whether we felt that there had been progress over the years since then, because there were, I think that was either 2 or 3 years prior to what we were doing. So we satisfied ourselves that there were now mechanisms in place for people in that area of the office to raise complaints that were significantly better than those that had been in place at the time. We looked at the people survey results for that part of the office, which were significantly better than they had been at the time of the alleged events taking place. And we, I think, identified some potential enhancements still further for ways in which people in that area of the office could be supported. That's my recollection of it. So those were very much about learning lessons from events which had happened around 2014, if I remember correctly, as opposed to more contemporary events.
Okay, thank you, Convener.
Just before I move to Alison Johnson, Murdo Fraser has indicated one supplementary to something that was said. Murdo Fraser.
I've got a couple of supplementaries, Convener, but if I ask those, I won't need to come back in later. Would that help?
Well, that sounds like a good deal.
Would that be a good compromise? Yes. Thank you. Thank you. Good afternoon, Ms Davidson. Can I just ask a couple of questions around this issue of the instruction from the Permanent Secretary on the 21st of December? We know that the Permanent Secretary was involved in the oversight group that had been established around the judicial review. Why do you think, or did she explain to you, why it was necessary then to get another opinion on this? Would she not have had all this information available to her as part of that group that she was a member of?
So, again, I think you would need to ask the Permanent Secretary about that. She was asking me as a senior colleague to ensure that that was brought together in a way that would be apt for her to take a decision. And she may have concluded that it was appropriate to ask one of her most senior team to do that. But again, you would have to ask her, I think, precisely for her reasoning. Okay, thank you. Well, we have the Permanent Secretary coming in, so we can pursue that. And she gave you this instruction on the 21st of December. I hope it didn't spoil your Christmas too much. Did she ask you to prepare this within a certain time frame? I can't recall the specific time frame, but it would be unusual in such a commission not to specify when the advice was required by. So my guess is the fact that it was provided, I think, by the 20th of December suggests that that was the Commission deadline.
That was the deadline. Okay, and my final question, Convener. You mentioned in your answers to Angela Constance that you were bringing together financial advice. Can you explain the relevance of that to this particular issue?
So, accountable officers, and of course the Permanent Secretary is the principal accountable officer for the Scottish Administration, always have to have regard to a number of accountable officer tests in relation to, well, in fact, in relation to anything that they do. The formal delegations that allow money to be spent by the Scottish Administration require these things to be taken into account. So, regularity, propriety and value for money is the formal way of describing those. And any accountable officer, whether at principal accountable officer level or anywhere else in the system, if considering a particularly knotty issue or contentious issue, would want to have regard to those accountable officer tests in relation to the decisions they were making.
But if I can press you a little bit further, when you say the financial matters, are we talking about legal costs or is there something other than legal costs here?
My recollection would have been that it would be the legal costs. In other words, costs inherent in proceeding with the action. Yeah. Yes, these were all inherently related to the continued defence of the judicial review or otherwise.
Right. So you perhaps have had to provide an estimate of, if the case had continued, what the additional costs might have been.
Again, I can't recall the detail of whether that was in it. I suspect that the advice from the principal finance officer certainly would have been normal in such cases for the advice from the principal finance officer to say, you know, in continuing to spend public money in a case like this, these are the things to which you would wish to have regard.
Yeah. Okay. Thank you. That's very helpful. Thank you, Convener.
Alison Johnson, please, and then Alex Cole-Hamilton.
Thank you, Convener, and good afternoon. I can't help but, on reading the evidence provided today, reaching a conclusion that your actions certainly seem to have been decisive in bringing matters to a close. So, can you just elaborate on why you decided to take a more hands-on approach at the point that you did around the 20th of December to directing senior officials in relation to the judicial review?
Again, my recollection, and I think the timeline speaks to this to a large extent, as indeed I think Mr Coquette did, was that pressure was ramping up considerably over this time. There was a very small number of people, as Mr Coquette said, involved, or a relatively small number of people involved, who were being asked to look for further documents, who were being asked to give evidence in a formal legal process. And that was all being done under immense time pressure. People were very, very pressurised and I think it's fair to say anxious and stressed by that process. And not all of those people were within my area of formal responsibility, but some of them were. And it felt therefore important to me to provide whatever help and support I could in order to enable them to discharge their responsibilities appropriately as part of the legal process, but also as part of my duty of care to them as Scottish Government staff. So, for example, asking SGLD to provide additional support to them and advice to them was in line with that. And I think that may well be, again, I can't recall precisely why I was asked to issue the email that I refer to in my written evidence, seeking to be very clear about the nature of searches. But again, I think it may well have been because of my seniority, that it was helpful for people to get that very clear line from a senior official, albeit that the content of that email would have come and been drafted for me by the lawyers.
On the nature of searches and the need to be very specific in order to obtain optimal information, were IT specialists involved, or people, did you have any assistance from those who would really know how to get to the bottom? I mean, sometimes I struggle myself with searches, so there's, there are those who have great expertise in this. Did you seek such advice or input?
So at the point of issuing that email, the purpose of that, as I recall, was to be very clear about where people should be searching. So, for example, to be clear for the avoidance of doubt I don't know whether this was made clear before, but for the avoidance of doubt, that things like WhatsApp messages and everything, all of those things should be brought out. Later on, and I think it's in the, down as being on the 24th of December in, yes, that's right, in the Scottish Government timeline, our IT specialists were involved. I was involved in bringing them in. Digital was also within my area of responsibility. And as Mr Coquette said earlier, there had previously, as I understand it, been concern about bringing more people into searches because of the very sensitive nature of what was being searched. And I recall I was part of a discussion on or around the 24th of December, which recognised that we would have to bring IT specialists in from the IT team. At that point, there was an agreement of some very specific terms that they should be asked to search for, and specific mailboxes and H-drive files that they should be asked to search in. And I think, although I can't specifically recall, but I think it would have been correct that as the senior officer responsible for the digital directorate, I would have been asked to sanction that search, because clearly searching all of people's information was a fairly sensitive thing to do. So I think I did sanction that on around the 24th.
And did you feel frustrated that that level of specificity hadn't been suggested earlier?
It was... I certainly recognised that so the reason I'm hesitating is because I don't know precisely what was specified earlier on, so I can't say for certain. I think I shared the general frustration that documents were being found late in the process, which clearly assisted nobody involved. So yes, there was a general frustration about that.
And, you know, just for absolute clarity, what prompted you to advise the Permanent Secretary to concede the judicial review?
So to be clear, I didn't advise her to concede. I provided the information and I didn't draw a conclusion. It was left to her. What I had been asked to do was to provide the information in a means that would enable her to take a decision to concede. So it was her decision.
And did she discuss that information with you?
I don't recall discussing the contents of it. I think there may have been a call which involved a number of people, principally legal advisors, following my submission on the 28th. And again, I think the timeline suggests that the timeline suggests that on the 31st of December, the Permanent Secretary requested additional legal advice. I think that request may have been made in the context of a call which a number of people were on, not simply myself, where she was feeding back her thoughts, her reaction to the report that I had given her, and on the basis of which she requested additional advice. That advice was not from me or passed through me, and my recollection is I didn't have any further role in providing information to her at that time.
Okay, and finally, Convener, can you confirm the basis on which the Scottish Government conceded the case?
So my understanding of the basis was, I don't have it to hand, but was as Mr Coquette stated at the end of his evidence when he read out the basis of the concession. That was my understanding. As I say, I was not close to all the detail of it, and I couldn't attest to the legal arguments. So my understanding is the same as anyone reading those words.
Okay, thank you. Thank you, Convener.
Alex Cole-Hamilton and then Jackie Bailey.
Thank you, Convener. Good afternoon, Ms Davidson. I should say for the record that Ms Davidson and I have a long-standing professional friendship from times we worked together while I was in the voluntary sector. I'd like to start by asking you a semi-personal question, Sarah, Ms Davidson. I think in my earshot, certainly, you'd been talked about as a potential future Permanent Secretary yourself. So a lot of people were surprised when you left government in 2019. Can I just ask, was your departure from government in any way linked to your feelings about this episode and how things have been handled?
Absolutely not.
Okay, that's absolutely fine. Can I move on to your reference in your written advice about citations around the 17th of December, and that a number of staff had been issued citations to appear before the Commission. I think it would be very helpful if you could provide us, perhaps in writing at a future date, your recollection of who exactly was cited to appear. But I have one specific question. To your recollection, was the First Minister's Principal Private Secretary, John Summers, cited to appear before the Commission?
Not by my recollection. And I think in the Scottish Government timeline on page 17, in relation to 17th of December, it sets out those who received citations. I'm pausing now because it does not say that that's a comprehensive list.
Right.
But certainly, had you asked me who I recalled had received citations, the names that I would have recalled would have been those listed against the 17th of December.
The reason I asked for your recollection was if there was any variance from the list that we've been provided. So that's absolutely fine. You don't need to follow that up, in which case. I'd like to follow. A number of people have already asked about the report that you were commissioned to write, I think on the 21st of December. Urgently so. Just to clarify, the urgency, the catalyst for that report was a recognition that the balance of success against the arguable case was now so poor that there was a pressure to concede. Is that right?
So the reason I'm hesitating is because I don't recall that that was the way that the Commission was presented to me. In other words, I don't recall that the presentation or the Commission said, as you described it, this is now so poor. Can you kind of help us to concede, as it were? It was clear to me that a point had been reached where clearly, on the basis of what had come to light, the lawyers were saying, or rather, whatever the Permanent Secretary had heard, presumably, but I don't know for certain, in that consultation on that date, led her to think, I need to take stock now. Okay. And again, I think from what one knows in the background, the thing that one would want to take stock on in her role as Permanent Secretary would be the prospects for success.
So if I can read from your written submission, you talk of the project that you finished on the 28th of September. You say, I submitted this to the Permanent Secretary on or around the 28th of September. My understanding is that following receipt of this advice, I believe after having obtained further legal advice, Permanent Secretary concluded the petition should be conceded. Now, I infer from that the catalyst to your report was legal advice. And I'm not asking you to go into the legal advice for obvious reasons, but that's, I think, what strikes me from this. I just wonder, was your report there to help the Permanent Secretary break some kind of impasse? That perhaps that she was at loggerheads with legal counsel as to whether to continue with the case, and that the fact that after receiving this, that she went back to legal counsel either to say, no, I think we should continue, or vice versa?
No, that wasn't. I had no impression of that at all.
Okay.
And it would be quite normal in the way of doing things for a Permanent Secretary, or indeed anyone senior having to take a decision, to ask for something formal to enable them to take that decision, partly for the record, but also so that they could satisfy themselves that in a fast-moving situation they had properly considered all of the matters that should be before them.
I understand. And I think my final question then, Convener, just moving on to your being commissioned to look at paragraph 10 in the immediate aftermath in the lessons learned. And obviously we know that was taken out of your hands, so to speak, with the commissioning of the Dunlop review. Did you have a chance, or did you make any recommendations for immediate remedy to the policy? Or to put it another way, did you recognise that leaving it unchanged would present a barrier to potential future complainers coming forward, given what had happened with the judicial review?
So I didn't have an opportunity to even make the progress, even to scope the review. I think it was within a day or something of this being suggested that the decision was taken that in fact this should be done externally. So to the first part of your question, the answer is no. Again, it's hard to recall precisely, but I certainly do remember that there were discussions about what would happen in the eventuality of another complainer coming forward. Not that was known, not that there was any particular instance in view, and a recognition that if somebody else did make a complaint under the procedure, then the lessons which had been possibly not learned in the sense of writing them down, but clearly learned by everybody who'd been through the previous 12 months, would have to be taken into account in decisions such as the appointment of the investigating officer and the way that the investigation was carried out.
Okay, that's fine. Thank you very much.
Thank you. Jackie Bailey, please, and then Maureen Watt.
Thank you very much, Convener. Good morning, or indeed good afternoon at this point. On the 19th of December 2018, further material turned up that hadn't been previously identified, and you were asked to intervene. Can I ask, who was responsible for the collation of that material in the 3 months prior to your intervention?
So my understanding was that the responsibility lay both with the litigation team in the Scottish Government Legal Directorate and with the point of coordination in the Permanent Secretary's office.
Who is the point of coordination in the Permanent Secretary's office?
The Permanent Secretary's private secretary.
Who was that at the
That
time?
was below SCS level, so I don't think the Scottish Government has released their name.
Okay, thank you. So you were then asked to compile the emergency report we've heard about on the 21st of December. Given that you didn't make recommendations, you didn't have meetings with council, do you understand why your report has been withheld from the committee?
No, I don't. I understand that the Scottish Government has withheld it, but that would be a matter for them. I don't.
Okay,
they told me that was the case, but I don't know
okay.
why.
I'm trying to understand if there were no recommendations, there was no legal advice contained in it, it was a narration of the facts?
It contained legal advice. It contained advice that was given to me by SGLD, which they would have obtained from a number of sources.
Okay.
Pardon me.
Did your report touch on the timeline of when the information in relation to Judith McKinnon's dual role of both supporting the complainants and being the investigating officer was first revealed?
My recollection is that it would have contained advice from Legal Directorate about what was contained in the documents that Judith McKinnon had turned up late in the process. If I knew, I can't recall precisely how they bore on the overall timeline, but the legal advice in the report would have said something about the import of those late productions.
Did you have access to external legal advice that was provided to the Scottish Government?
Not directly to me, but if there was any external legal advice, it would have been reflected in what Mr Coquette gave me.
Okay, so based on what Mr Coquette knew, is there a timeline for when external legal opinion was taken in relation to the role of the investigating officer?
I'm sorry, I'm not sure how... could you just be clear about the question?
I'm trying to establish at what point external legal advice was taken and how that was reflected to you in relation to Judith McKinnon's role as the investigating officer. You'll have seen the conversation about 19th of October, 23rd of October, that kind of thing.
Yeah, so I don't know when that was obtained.
Okay. Given that we heard Paul Coquette say that there were daily meetings with the Permanent Secretary's office, were you surprised you were asked to do this report, given your lack of involvement up to that point?
No, as I say, it wasn't unusual for the Permanent Secretary to ask a DG on her behalf to do a bit of senior work like that. So, no, I wasn't.
Okay.
I wasn't particularly surprised.
Okay. After you submitted your report on the 28th of December, what follow-up was there?
So, as I said in response to Ms Johnson's questioning, I recall a telephone conference call, which I think, and again, jogging my memory by looking at the Scottish Government timeline, I think that would have been on the 31st of December. And again, to the best of my recollection, that was the opportunity for the Permanent Secretary to feed back to a number of people, including her legal advisors and others, what her response and reaction was to the advice that I'd given her. Again, my recollection, and it's reflected in the time entry for the 31st of December, was that she actually had some further questions which were essentially about the legal advice, and she asked for some additional legal advice. I can't recall precisely what that was, and I see the Scottish Government was applying LPP to it anyway. It wasn't advice that was sought from me, or indeed that I think I saw.
Could I ask who was on that conference call?
I can't recall. I can't recall. I think the likelihood would have been that Paul Coquette would have been on it. I think it's likely that her Permanent Secretary would have been on it, possibly a communications advisor. But I
Not the Lord Advocate?
I honestly can't recall. I would be misleading you to suggest one way or the other. I can't recall.
That's a shame. Okay. You say that in January 2019 you were asked to review paragraph 10 of the procedure. Why just paragraph 10? Because there were other grounds in the petition.
My recollection is the Scottish Government only conceded on the matters relating to paragraph 10, and therefore the Scottish Government, as far as I can recall, took the view that there was nothing else to be reviewed at that point. Whether they've changed their mind since, I don't know, but that was the position at that time.
Okay. Can you make an observation that why were you being asked to do this in January, 2 months after it was known there was a problem? It's a bit slow.
I think, so there were, again, you'd have to ask the Permanent Secretary that. But that, I was being asked to do it in the light of the fact that the judicial review had been conceded, and clearly at that point, the Scottish Government, the Permanent Secretary, had conceded that the application and interpretation of paragraph 10 required to be reviewed.
Okay. Has anything happened, in your knowledge, to paragraph 10 since you provided that report in January 2019, or does it remain the same?
So I didn't provide a report at all. As I said, I didn't, within days, if not hours, of my being asked to review it, the decision was taken that, in fact, it would be more appropriate for that to be external. Okay. And I don't know what's happened since then.
Okay. We heard from Paul Coquette, and this is my final question, Convener, that this was the Perm Sex procedure. She drove the policy development. She clearly had a key role in implementation. Did she drive the judicial review process too?
So she was the respondent to the judicial review process.
I mean, internally, was she the one that was kind of everybody was reporting to?
So if there was a client, as it were, in the judicial review process, then the Permanent Secretary was the client, yes. Okay. Often discharged through her office for obvious reasons, given other business, but yes, she was the client.
Sure, but she was the one you reported to, she was the one commissioned the report from you, so she was the one in charge?
Yes, correct.
Okay, thank you very much.
Can I just ask for the clarity of the official report? In answer to a question to Jackie Bailey there, Ms Davidson, about that call, you said her Permanent Secretary.
Sorry, I meant her Private Secretary. Sorry,
you did,
yes.
you meant her Private
I meant her Private Secretary.
Thank you very much. Margaret Mitchell.
Could I ask you if you're aware of the offer of arbitration to deal with the dispute over the competency and legality of the procedure?
Not at the time, certainly not as I recall, no.
So you were never aware of it by anyone?
Not contemporaneously, as far as I recall. Clearly, I know about it now, but I don't recall being aware of it at the time the offer was made, and nor would there be any reason for me to have been, because I wasn't involved in the legal discussions.
Do you know when you did become aware of it?
No, I don't recall, but it could have been as recently as through the evidence provided for this committee.
All right.
But I can't say for certain.
So there would be absolutely no possibility of you knowing who took the final decision to reject arbitration?
No.
Right.
No, I
Thank
wasn't
you
involved in that at all.
Maureen Watt.
Thank you, Convener. Afternoon, Ms Davidson. You will have heard me ask Paul Coquette about how often and by what means any ministers were kept abreast of what was happening on all these legal discussions. Are you aware, or were you copied into any briefings that went to ministers? And are you aware, for example, whether your report was shared with ministers, or was it purely the Permanent Secretary?
So I wasn't copied into, and nor would have expected to be aware of any briefings going to ministers during the process of the judicial review. My recollection, and this would have been normal, was that my advice to the Permanent Secretary would not have been copied to ministers. What she then did with it, you'd have to ask her, but I certainly was not aware that my report per se went to ministers, and it was not directed to them.
Okay, thank you. Thank you. Ms Davidson, you just answered a question from Margaret Mitchell about arbitration. Can I ask, were you aware of the offer of mediation when that was made?
I don't recall. I may have been, but I certainly wasn't involved in any decision about how it should be handled. I may have been aware at the time. Nikki Richards, pardon me, may have updated me as part of our routine management meetings, but I couldn't say with certainty, and I certainly wasn't involved in handling it.
Thank you. In your submission to the committee as well, under the handling of complaints part, in fact, you said that in January 2018, Nicola Richards informed you that 2 of the individuals who had previously raised concerns were likely to make a complaint. And you said that she, in a previous catch-up meeting, she'd discussed the appointment of the investigating officer with you. And I wondered, did she say to you who that investigating officer was?
Yes, she did. She told me, as I think I said in my written evidence, as part of a normal catch-up, that she was... should the things which were being treated as concerned at that time, should they ultimately evolve into formal complaints out of the procedure, that she was considering appointing Judith McKinnon as the investigating officer.
And were you aware at any point that Judith McKinnon had had previous involvement?
Again, by recollection, as I think it's likely that I would have been aware of some previous involvement. There is no reason at that time for that per se to have given me any concern. But yes, I think I would have been aware.
Right. Also, and I can't remember who you were answering to earlier, you said about having to undertake another check about documentation for the judicial review, that there hadn't been clear advice given before about what information was required. Who had given that advice before?
So my assumption is that advice about how to conduct searches in relation to a legal process would come from the litigation team in the Scottish Government Legal Directorate, either directly to individuals who were required to search or indirectly via the coordination point to the Permanent Secretary's Office. As Mr Coquette set out earlier, the grounds for the judicial review clearly were evolving, so I would imagine that a number of requests for documentary checks might have been required. I don't know how many there were, I wasn't close to it. But that's what the process that I would expect to have taken place was.
And can I ask if you were shocked at what was found by this second trawl that was instigated by you?
I wasn't close enough to the process to be able to slot that into an understanding of the pleadings, such as that I would have a reaction one way or the other.
And finally, from me, I don't see anyone else indicating. I noticed you also said at the beginning of this session that it was fairly normal for you as DG not to have been involved in issues of human resources, and that would be very much left to Nicola Richards and her team. Is that normal within the setup of the civil service, where a DG would be separated from day-to-day workings at director level?
So the model that the Scottish Government has followed since 2007 is one that we describe as a director-led model. So directors do have both formal delegations of quite significant financial and other responsibility and a large degree of operating autonomy on a day-to-day basis within their areas of responsibility. There are, I forget how many, but there are a large number of directorates, and I wasn't the only DG who had a large number of portfolio areas within my area of responsibility. So in practical terms, that was entirely normal, whether in policy areas or in areas of professional specialism. Although I think it's fair to say that in areas of professional specialism, there was a particularly high degree of autonomy. As a DG, I was not qualified HR specialist or a qualified finance specialist or any of the other areas of responsibility in my area. So the role that I had was to support my directors and to seek assurance from them that the way in which they were going about their jobs and discharging their responsibilities was what I would expect. So I would ask questions to check that they were thinking things through properly and going about them properly. But it would be, and again, my fellow DGs would do exactly the same, but it would be entirely normal for them to have a high degree of autonomy in discharging their functions.
Would it also be normal for these directors at that level to report directly to the Permanent Secretary on specifics, bypassing their own DG?
Yes, particularly on corporate issues. Indeed, I think I mentioned in my opening statement that my role was only created at the point that I took it up. Now, there'd been a variety of different ways of handling corporate functions over the years before that, but quite often the heads of corporate functions reported directly to the Permanent Secretary without anyone in between. And when the DG role was created, it was recognised that there were some matters, particularly very sensitive senior staffing issues, and issues where advice had to be provided to the Permanent Secretary in her role as Principal Accountable Officer, where quite normally directors would provide that directly to the Permanent Secretary.
Yeah, you said that in HR terms you're not an HR professional, wouldn't be expected to be. But from my recollection, the director's not an HR specialist either.
Not at the moment, no, but Judith McKinnon, who was responsible for the bit of the People Directorate, which required specialist HR expertise, was highly qualified in that respect.
This is a very open question, but it has been asked by colleagues of other people. Hindsight is a wonderful thing. Looking back, do you regret that the structure of the organisation is such that you didn't have a more direct role in this?
As somebody who was neither bringing specialist HR expertise nor specialist legal expertise, I think from my understanding of the process, which is as I've set out, necessarily limited, it's hard to see what additional, what I could have brought that was additional to that, other than just another pair of eyes.
Okay, if no one else has any other quick questions. No, thank you very much, Ms Davidson, for your evidence.